Well, good day and welcome. My name is Josh Drayton. I am the Director of Communications and Outreach for the California Cannabis Industry Association. And you have tuned into our educational webinar on the permanent regulations with the California Department of Food and Agriculture. So today we're very lucky to have Richard Parrott with us. Richard is the Director of the California Department of Food and Ag's Calcannabis Cultivation and Licensing Division. It's a mouthful.
Yes, it is.
Just a little bit about process here. What we're going to do is we're going to review a PowerPoint on CDFA's permanent regulations. We will be taking questions online and reviewing some of those. So we plan on running for about 45 minutes. We will be taking all of the questions that don't get answered through this webinar and submitting those as well for answers. So do know that we will get as many answers to our audience as possible. So without further ado, we will start with Richard Parrott and his PowerPoint on CDFA's permanent regulations.
We're good to go?
We're good to go.
Thank you, Josh. Thank you. And I want to thank CCIA for having me here today for the opportunity to kind of walk through our permanent regulations and give a brief update, and then looking forward to questions that we might have afterward. So we'll just start with this timeline here that we have put together. It goes back to 2015 and takes us through the end of the year, through the end of 2018, and kind of gives some key landmark events that happened along the way. Some people have likened this to like a Chutes and Ladders game board. Other people we've heard said it kind of looks like a roller coaster, which I think, in some cases, 2017, 2018 was a little bit of a roller coaster ride with all the things that we all learned together. Just highlighting a few major things, of course, January 1st, 2018, the Malcursa went into effect where everything kind of kicked off. Midway through 2018, we readopted our emergency regulations. We started with a set of emergency regulations, and then we readopted those. In the middle of the year, some things did change through that readoption, and that was a result of things we learned in that early part of 2018 as we started out with temporary licensing. It afforded us an opportunity to make some minor tweaks in the emergency regulations. We issued our first annual cannabis cultivation license in October of 2018. It was issued to a farmer up in Humboldt County. Shortly thereafter is when we had almost like a mad rush at the end of the year for temporary licenses. So we had issued a few annual licenses, and then we just had an influx of temporary license applications, and so that became our focus as far as processing applications at the end of the year. So the permanent regulations were adopted by OAL on January 16th, 2019, and went into effect immediately upon adoption. Our full regulation text is found on our website, which is calcannabis.cdfa.ca.gov. You can look for the area referencing our regulations. You can see the full text. You can see also all the documents that were submitted to OAL. And our document that has all of the comments and responses as well that came in through the 45-day comment period, as well as the 15-day comment period.
Kept all of us very busy.
Yes, it did. All of us, including us, lots of comments, lots of comments, lots of responses. So just high level, our regulations are organized by 7 articles, starting with definitions, going through what's in the application, licensing, site-specific requirements, all the way down through records, track and trace, inspections and enforcement. Same framework that we had for the emergency regulations. Now these are no longer emergency regulations. So wanted to highlight some areas. Of course, today we don't have time to go through the entire set of regulations. I think our text is about 76 pages of text. But these are just some highlights that came from the permanent regulations that would have been different from what was in the emergency regulations. We clarified our mixed light definition by really specifying different types of light combinations that could be found in mixed light. We clarified that outdoor cultivation prohibits the use of light deprivation. There were a lot of comments regarding that part of the regulations as well. So the final regulations did clarify that. And then in our non-manufactured cannabis products definition, we clarified keef and how it's aggregated. I think there were some some little tweaks that we made in that definition to make sure we really hit the mark on that. So in our applications, we did clarify that CDFA could no longer issue any temporary licenses or extend them past December 31st, 2018. That was in the statute. So on our final filing, we did clarify that could no longer be done. With regard to California Environmental Quality Act, we put in some clarifying language about what's acceptable for evidence of compliance with CEQA is what we all use instead of saying California Environmental Quality Act. What can be provided to demonstrate compliance with CEQA or exemption from CEQA. In our emergency regulations, I think the language was maybe a little more, needed to be fine-tuned, and we feel like in our permanent regulations, we've really fine-tuned in that definition. And then we also clarified shareable common use areas between licensees. We did receive a lot of questions about that, about if there were multiple licensees, could they share common use areas like bathrooms, hallways, break rooms, things like that. So we clarified that in our application portion, as well as we clarified in a situation where you have a one licensee with multiple licenses on the same premises, what areas can be shared as well. This gives an overview of our license types. We do issue 17 different types of licenses within Calcannabis. Going across the top, it's the type of cultivation, outdoor, indoor, or mixed light. And then going down this chart on the left, those are the sizes of the grow, starting with specialty cottage being the smallest, working your way up to large licenses with some notes in there. Medium licenses are limited to 1 until January 1st, 2023, and then the large licenses are prohibited by statute until January 1st, 2023. The other 2 licenses are nurseries and processors. And I do always like to note that everything above processor was created through statutes, through Malcursa, nursery licenses, and all of the others. The processor license was one license that was created through our rulemaking process. Early on, conversations with the industry, with all of the farmers out there, created a need through the conversations for a processor license. So that was created through regulations. These are our application fees for an annual application. There is a non-refundable application fee. The fees are tiered. We are different than our sister agencies. I think they all have a flat rate of $1,000 application fee. Ours are tiered, and they're based on the license size. The fees were developed for us by an economist who worked with us, who looked at our standardized regulatory impact assessment document that was put together before we went into rulemaking. Looked at production, estimated annual production from these different license sizes, and so the fees were developed in order to, based on the output of that license size. And then these are the actual license fees. Same thing, they are based on the size of the cultivation operation. Wanted to clarify the fees, both the license fees and the application fees. Those fees fully fund our program, no more, no less. So the fees cover our operating costs of our licensing, compliance, and enforcement program. These fees are in regulation so that they can be changed if we do need to adjust those fees as we move forward in subsequent years. But once again, the fees are based on that annual estimated production of the various license sizes. So some highlights here on site-specific, in the area of our regulations that touch on site-specific requirements for the permanent regulations. We modified the different types of carbon offsets that are available to the licensee to cover them for emissions from their previous annually licensed period. We also clarified in our generator requirements, and this actually came from the Cannabis Advisory Committee meetings. There was a request there to allow an aftermarket non-resettable power meter if the generator was an equipped one. In the regulations, initially, it could have been interpreted that that could be done, but a request had been raised through the Cannabis Advisory Committee, so we clarified that in the permanent regulations as well. Some highlights from records and track and trace. We clarified for the immature plant lots that for an immature plant lot, which can be up in groups of up to 100, that they need to be uniform in strain. We also clarified which activities need to be entered into the track and trace system. That, once again, was a result of learning things from industry, learning things from inspections, happening at temporary licensed locations, of just really clarifying what activities need to be entered into the track and trace system. And then that we also clarified that an annual licensee will need to input information in the track and trace when they conduct transactions between a temporary licensee and someone who's an annual licensee. For our enforcement part of our regulations, we added a section that's called emergency decisions. That allows us to, in an event of what we would consider something an emergency decision, like an immediate threat to public health, worker safety, an immediate threat to the environment, it allows us to put a product or basically a license, an operation on an administrative hold and prevent them from conducting any further business. We see that as something that would be enacted if we're in an extreme situation, but we did put that in the regulations. And then we also clarified that for our informal hearing process, there are certain instances that would result in an informal hearing, that informal hearing, the results, the respondent may appeal that to the Cannabis Advisory, Cannabis Control Appeals Panel. This is our current statistics. There may be some questions out there about what's happening. Where do things stand today? So these statistics are fresh as of this morning. So as of this morning, we have 6,804 active temporary licenses, 10 active annual licenses, 3 active provisional licenses. In addition to those 13, we have 59 approved licenses that are either annual or provisional that are ready to issue pending payment. So the people have been notified your license is approved. Once we receive payment, those will be issued. So there is the potential to have close to 60 more as soon as payment comes in. And then we have 4,262 annual applications in-house that have been received to date.
Richard, while we're on the subject, are you able to talk about how many licenses and applications you received at the end of 2018?
Sure. So I mentioned earlier about the influx of applications at the end of 2018. What we saw is, last September, 1459, the piece of legislation that was passed to create provisional licenses, was going to be created a pathway for people who were in jurisdictions that would not be fully compliant with CCIA. So the law was passed to create this provisional license, but 2 key things are needed for the provisional license. You have to either have or have held a temporary license for that commercial cannabis activity, and then you have to be able to demonstrate as part of your annual application that the jurisdiction where you're located, that CCIA is underway. With that requirement to have a temporary or have held a temporary, we didn't want people to procrastinate. So we sent out a notice in probably, I think it was early November or mid to late October, telling everybody if you intend to get a temporary license, our authority to issue those expires at the end of the year. Please get us your application by December 1st to allow us ample time to process. In the month of December, or from that point up through December, we received a little over 9,000 applications for temporary licenses. For the year, we processed about 17,000 17,000 applications. I do have, if I can share this, this is out on our website. This is kind of 2018 by the numbers, so we do have this. It's an infographic. It has some key things that we're talking about today. That's kind of just a real interesting read for people to go take a look at. So yes, we were inundated with temporary license applications. We issued as many of those as we could, where the applications came in by December 1st. We were actually even able to issue some that came in after December 1st. Obviously, there were some where either they didn't have local authorization or the applicant didn't respond in time if we notified them that we needed specific information. So some did not get issued, but the majority of them did by the end of the year, which, you know, put those temporary licensees on a pathway of having a temporary that's valid for 120 days. In some cases, it's valid longer because if they submitted an annual application to us before the end of the year, we were able to extend that expiration date by an additional 90 days.
So a lot of applications at the last minute.
A lot at the end of the year.
So industry, always get your applications in early to expedite the process.
So the last page is information. Visit our website. We have a lot of information out there, and I know we'll be talking and taking questions. We do have some, I want to point out, very good information for applicants to read. If they haven't yet, it's called Guide to the Cultivation Plan and Guide to the Application Attachments. Those are on our website. If you have not read those documents, please do so. They're very helpful. We have templates in there for the cultivation plan is the part of the application that I'm sure people are familiar with. Our application is in what we call the phase of science review. That's where an environmental scientist is reviewing it, and they're verifying any of those environmental protection documents, like water documents that are provided, that are certified, issued by the Water Board or by Department of Fish and Wildlife. And then there's also the cultivation plan, which is their property diagram, premises diagram, all of those things. That guide to the cultivation plan has templates in there that the applicant can use to fill out. It's fillable PDF. It has samples of what a diagram looks like. So if you haven't read those, please do. And if after you read them you have questions, email us at calcannabis@cdfa.ca.gov. Call us at 1-833-CALGROW. If you have questions, please ask. Read the information and ask before you apply. Our goal is to get very clean, complete applications in the door, because that obviously helps us be able to process a lot quicker. And the last thing I do, this is a fact sheet that's out on our website as well. This is about provisional licenses. I think that there's been some misunderstanding out there, and I do want to clarify that provisional licenses, you submit an annual application. Still, there's no such thing as a provisional license application. So you submit an annual application. Based on our review, we're able to determine if you qualify for a provisional or an annual, and it's really going to be based on what city or county you're in and where they are in the process of having a fully compliant CEQA document. Okay, and this fact sheet gives a real good overview and has some nice flow charts about it too. And then we have, you know what? I think I held up the wrong one. This is a fact sheet about our regulations and highlights about our regulations. Sorry. We also have a fact sheet about provisional licenses that's on the website.
Well, and we'll make sure we get all of those loaded up in our resource section on our site and then sent out to our membership as well.
All right. Let's see. I think on this final sheet, the other thing is to just make sure, you know, there's a lot of people that use social media, so we are active on all three of those platforms: Facebook, Instagram, and Twitter. Follow us there. We're always, you know, putting out the most current information. If there's something we need you to know, where we have listserv sign up on our website as well, and then we'll also send the information out on social media. So please visit our website if you haven't. Sign up for email alerts. Call us if you have questions, or email us if you have questions. We're here to help guide you through the process, and what we want is the industry to be successful in getting to licensing. Okay.
Well, excellent. At this point, we'll start to move into questions. Excellent. So we do have, a set of questions that we're going to be asking, but please do send in your questions directly to the webinar. We will be reviewing everything that we can. And then if there are any lingering questions out there, we will make sure to get those to CDFA to make sure we get as many answered for our members as possible. So I'd like to, first start to talk about just kind of process. One, how permanent are the permanent regulations?
Good question. Yeah, so the permanent regulations, they're called permanent because they're no longer emergency. Emergency regulations only have a certain lifespan. In our case, that was 180 days, and then we had a readoption that gave us another 180 days. After that, you have to have in place what you would call permanent rules, permanent regulations. But permanent for now, if that makes sense. This is the start of our program. This is like I would call the baseline or our foundation of the program. As we move forward, we undoubtedly will learn from the industry. Annual and provisional licensees will be in track and trace. We'll be learning how that's working. We anticipate getting feedback from the industry. Things will be able to change as we move forward, as we learn, and we hear more from people, what's working, what's not. And we see that every year, or as we move forward, we'll be looking at what's working, what's not, what needs to change, what can change. Regulations will also, new ones will be created, and some may change through the legislative process, depending on new legislation every year. So permanent for now is probably good.
Okay.
But with the ability to change as we all work together and learn more.
And then moving forward, for the industry, what is your best recommendation for how we can affect change? Will we see, a trailer bill that could possibly trigger a public comment period? Do we focus most of our energy on legislation moving forward? Wondering if you have any recommendations.
I think that my recommendation would be if the industry sees things that are, in regulation, to engage with us, send us something in writing, articulating what the issues are, what the possible remedies may be, and I think that's a very good start for us to have that conversation. And I think that we'll also see, I know we'll see trailer bills and other pieces of legislation that will touch on the licensing authorities as we move forward. But I think, for a start, let's just say, if it's something that the industry sees and it's something that could be addressed in regulation, I would say to write to us and engage with us.
Okay, great. So just kind of reviewing 2018, we did start under emergency regulations. We had the readopt of the emergency regulations, 45-day public comment period, from the permanent regulations, and another 15-day public comment period for the final draft permanent regulations. So I'm wondering, during that process and working with the industry and learning more, what are some of the regulations that stand out to you that you've been a part of creating that you're most proud of or really reflect education that came from the industry?
That's a good question.
And that's not an easy one to answer. I think for us at CCIA, we've been acknowledging the reciprocal education that's necessary, whether it be the industry really learning from regulators on how to create policy, how to advocate effectively, and likewise for regulators, to learn from the industry on how they're implementing best practices, standard operating procedures. And we've gone about it in multiple different ways, so, what I'm trying to get at is, from where you started to where you ended, and so much of, what you have learned from the industry and, cultivators specifically, because they have a very unique set of concerns.
Yeah. So one that I think jumps out at me that probably got a lot of attention early on that I felt like we made significant progress on and got to a place where I think it was probably the best we could get was there was a lot of discussion around the definition of canopy and what a difficult thing that is when you look at what was in the law, you know, as far as license sizes. You know, when you're talking about 10,000 square feet, up to 10,000 square feet, up to 22,000 square feet of canopy. The whole thing came down to, well, what does canopy mean? We started with something that I think really the industry, it was unsettling for them. Through the conversation and feedback, we got to a place where, you know, we talked about canopy being identified by boundaries or identifiable boundaries, because it's a very hard, for purposes of enforcement, it's a very hard thing to define because you're talking about a plant that's growing. So I felt, and you know, I think that there's probably still maybe some disagreement with some you know, farmers out there, but I felt like we all came to a place where it was workable for everyone. And it was definitely, when I first came into this position, that was one of the biggest things that was talked about. And I feel like we made good progress.
No, I think you have made good progress, and I think, you know, that you know, helps me kind of touch upon like definitions. And as an industry, I think we've taken for granted that everyone has the same level of education. And really, the cannabis world has its own terminology for everything. So really getting down to, you know, defining what these terms really mean and making sure everyone has the same understanding, you know, it is a heavy lift for all of us. And with that being said, you know, one of the definitions that I'm starting to see a difference between CDPH and Calcannabis is that of processor. So I'm wondering if you can kind of touch on, you know, from the CDFA's standpoint and viewpoint, you know, what kind of processing activities are allowed?
Sure. So we, in CDFA's regulations, we define processor or processing to mean trimming, curing, drying, grading, all of those activities that would happen to cannabis post-harvest. In CDPH's regulations, they have a definition of manufacturing that excludes processing as defined through CDFA's regulations. So I don't know if maybe there may just be a little bit of a misunderstanding of what it means. In public health regulations, they do use the word process in some of their definitions, but not with the intent of what is defined by CDFA as processing. And I believe that public health regulations are intending to, they see processing, like I just described, as those post-harvest activities as a cultivation activity, and that's why CDFA issues the processor license. So public health regulations, I believe are saying that a manufacturer cannot conduct those post-harvest activities.
Correct.
That would be a cultivation activity. I'm hoping that clarifies a little bit.
No, it does clarify it. And then moving forward, you know, one of the issues we've had as an association and through our different supply chain committees is that when folks reach out to the different licensing authorities, sometimes they do get different interpretations on, you know, different language. So just moving forward, you know, can you talk about, will there be, you know, any sort of effort that the three licensing authorities, you know, would clarify terminology or, you know, interpretation of regulations together? And if so, how will that be presented to the cannabis community?
Yeah, I think that's a really good question. Moving forward, my hope is in 2019, we talked about 2018 and all of the different things that were happening. My hope is in 2019 that we do have that opportunity to look at things such as this and create a way for all of the licensing authorities to have almost like a unified message out to the licensees to clear up things where there may be questions like that, and really be able to focus more on education in 2019, education and outreach. So we all worked very closely together in 2018 in crafting our regulations to try and limit any disconnects between us or you know, overlap or all of us saying the same thing differently as much as we could. So my hope is that we can do that in 2019, is really look at issues where, such as this one about processing, and then have a message that comes out from, in this case, you know, either public health or CDFA to clarify any of that.
Yeah, that would be helpful for all of us. And I think, we're all gearing up for more education, whether it be for the industry, for consumers, for regulators. It's an ongoing process. I do want to touch upon, we have had a lot of reciprocal education that's been necessary between regulators and between the industry. So I'm wondering if you can talk about, how you've been educated. What have been some of the more successful things the industry has been able to provide? Whether it be tours, whether, visiting farms in Northern California and understanding, the unique challenges that they face being, behind the redwood curtain.
Yes.
But yeah, I think education has been a big part of, CCIA's focus, and likewise, it's been important for regulators to, work with the industry to educate them on how to advocate for good policy. Right. So yeah, if you want to talk about that just a little.
I think it's very very helpful for us. We were out on a lot of tours in 2018. I think that's probably one of the most important things for us to be able to see is how, out on a farm, how does this work? What does it look like? Our compliance and enforcement, our inspectors were out visiting as many of the temporary license sites as they could get to in 2018 to learn how things are working. We paired up our licensing teams to go out with them as well to get that education. It's one thing to see the regulations and process an application, but to go out and actually look at a business operation there's nothing more valuable than that. So I hope to continue that. We also, as we're working on some of our other programs, one of them being our appellations program, we did a lot of tours last year, and we intend to do more tours this year too to learn more as we're crafting that program. That's very helpful. And then, I think through that conversation, the businesses that are trying to follow our rules and regulations have that conversation with us and understand kind of what our difficulties are, and that conversation and communication is very, very, very invaluable.
Excellent. And that does kind of pivot me to talk about the Appellation program and other programs that are available right now. So California does have a legacy cannabis market that is built by craft cultivators, small manufacturers, and medical patients. There's a lot of concern in the industry just going through this first year of adult use. There's a lot of challenges and barriers to entry. The lack of local authorization has been very problematic for all operators in the industry. So I'm wondering if you could just talk about the Appellation program, but also what other regulations are in place or what other programs are available on the horizon that would ensure craft and sun-grown cannabis cultivators do have a future in California's market.
Good question. So two programs that are slated to be in effect that were created through statute by January 1st, 2021 is a program to establish a process where cultivators can establish appellations of standards, practices, and varietals. And then our other program is to create a program that for organic cannabis that's comparable to the National Organic Program. So those two appellations, we did about 7 kind of outreach meetings across the state last year around September to really gather a lot of input from the industry, get some thoughts from everyone, did these kind of workshop settings, really get a lot of feedback. That was very, very helpful for us. And then we've had subsequent conversations at various locations with various associations and visited some growers up north to really learn about appellations and what that means and what that has the potential to look like. We're really excited about those programs. I think that they're very well received by the industry. The small grower, the craft grower, they see a path there for them where this is something that has the potential to really help them. And then with comparable organics, we are the Department of Food and Agriculture has California Organic Products Advisory Committee that advises on all things organic. And a few months ago, or probably last October, that group is called COPAC. COPAC was able to create a cannabis subcommittee that is going to kind of advise us as we work toward starting to develop that comparable organic program for cannabis as well. So those things will be ramping up as we move through this year. Obviously, with needing to be in place by January 1st, 2021, that means new regulations later this year for those programs.
Oh, fun. Well, as a former Humboldt County resident, I do look forward to the Appalachian program and really, giving small craft farmers, a stronger pathway to get their product onto the market. Do you see that as something similar to, the wine appellation programs of Sonoma and Napa?
I think we're definitely looking at those programs. We've talked extensively with people in the wine industry, educating ourselves about wine appellations and learning how that works, and drawing as much knowledge as we can from that process. Looking at the process that's used to establish those appellations through the federal Alcohol Tax and Trade Bureau. Talk with them so we can understand their process. So we're looking at that as definitely a basis for what could be. What it ends up looking like, we don't know, but we'll definitely involve conversations with the industry, obviously, so we could get that feedback as we continue to move forward.
That's great. I don't want to go down a rabbit hole and talk about the processing of annual licenses. You've definitely highlighted that there are challenges, and there's challenges for each of the licensing authorities, whether it be when the applications came in or, really training staff to bring them up to par. Richard and I were talking prior to this, and I'm just saying, even as an industry association, it's very difficult for us to bring on new folks because there's so much that needs to be explained about an emerging industry, whether it be the regular language we use or, learning best practices and standard operating procedures from all different types of license holders. So I do want to let folks know, Lindsay Robinson would be doing this interview right now, but she has gone to the building to give testimony for Senate Bill 67. Senate Bill 67 is authored by Senator Mike McGuire and Assemblymember Jim Wood. This bill is on a fast track. What it would do is it would give the 3 licensing authorities the ability to extend temporary licenses, acknowledging that getting through the application process has taken more time than the licensing authorities knew. So SB 67 is being heard. It started at 11 a.m. in the Business Professions and Economic Development Committee. And if this does pass through, it would go into effect immediately upon signature of the governor. So that's all I'm going to say about SB 67 and the annual licenses. What kind of questions are you hearing most from the industry about annual licenses, and what are some of the bigger pieces that most folks are missing?
Okay, so I think the biggest question we're hearing is, when will I get my annual license? How does this work? How fast, how long is it going to take? That's one of the questions. How long will this take? So if I could make a couple of plugs here. If you have a temporary license and have not yet applied for your annual license, please do so immediately. Don't wait. Turn in your annual application. If there are pieces of the application that you don't yet have, for instance, if you're still working on getting, documentation with Fish and Wildlife or Water Board, send us your application and put a placeholder where those documents would be explaining that you're working on it. But if you have a temporary and you haven't applied for an annual, please do so immediately. If you've already provided us an annual application, let's say you applied last year in 2018 and your temporary license was extended, and let's say that you didn't have documents back then and you gave us placeholder documents, don't wait for us to contact you. Go back into your online account where you sent your application look for those placeholder documents and replace those with the current ones. If you were working on your cultivation plan and your diagrams, and you were waiting on some other information and you have it, go in and do that. Go in and get those things fixed up now, because if you don't, and we get to that point in the review of your application and see that that needs to be corrected, we're going to send you a notice, and it's going to tell you you have 90 days, because by regulation you have 90 days. But be proactive, log in, see what may be missing, and start fixing those things up now. That'll help expedite our process. We have a lot of applications that are in process and are on target and on schedule to have that annual license issued before the temporary expires. But this is my opportunity to ask the industry to help us. Go in, get into your account, and if you do get a notice from us that it's called a deficiency notice, that something is deficient and needs to be replaced, don't wait the 90 days. Please go in and fix the deficiency immediately. And if you're not sure, call us. When you fix the deficiency, there's a little part in the system where you clear the deficiency notice, and it notifies us that it's been cleared. That goes and gets assigned to our staff, so they know, hey, you took an action on your part. We can go in and move it along. So I'm really just asking everyone out there to kind of be proactive on your part and help us. Don't wait for us to contact you.
Thank you, Richard. This past year, 2018, was really rough for a lot of the industry, whether it be staying compliant or the barriers to entry that many have had, specifically due to, a lot of the lack of local authorization that's available out there. All the while, this has, only roughly 35% of the state does have these regulations. Folks have really struggled to be successful this first year. So that brings me to, somewhat addressing enforcement. Governor Newsom recently announced that he was pulling the National Guard from the Mexican border and was going to bring a portion of those up to Northern California, specifically to focus on trespass grows, the grows from cartels that have been happening in national forests. So I'm wondering if you could kind of talk about, what the enforcement priorities are for CDFA.
So for CDFA, we work with our partner agencies, Department of Fish and Wildlife, Water Board, and the local jurisdictions, local law enforcement. Priorities really from an enforcement perspective, we're really trying to focus on education and compliance this year. Our goal here at CDFA is to get people licensed, get them into the legitimate market, so they're on a path to success. We will be going out. We're not law enforcement. Our enforcement teams are not peace officers. We have the right to conduct inspections at licensed sites. So we'll be focusing on education in this first year. And then we'll also be working with our local, local partners on businesses that may have had temporary licenses and just never went forward with an annual license, and just kind of dropped off, but really it's going to be first and foremost really on educating the industry on here's what you need to know. If they're doing something that's not in compliance with our regulations, educating them, providing them the information. Not going out and hammering people with tickets or citations in this early part of the annual licensing period. It's really getting people educated, because that reduces your need for enforcement, is educating. We also will be working with, as needed, if we're contacted by a local law enforcement or one of our partner agencies asking us if a site is licensed, then we cooperate with them. We'll look in our records, let them know if they are licensed and if they're not. And if they're not, then we may be participating in a stronger enforcement action on a business or a cultivation site that's just not licensed yet.
Right.
But I want to make sure that people know that our we really are out there to educate people to understand how to comply with the laws.
Yeah, and I think that education piece, as we've talked about a few different times, is really necessary. The education between the industry and regulators, but ultimately, educating consumers as well, and how to identify product that is purchased from a legal establishment, and the benefits that provides, whether it be fully tested product. I mean, let's be honest, we're going to have cleaner cannabis in California than our food supply chain, which is a good thing, which we fully support. So, moving forward, into 2019, do you think we will start to see, more jurisdictions open now that the 3 licensing authorities have finalized their regulations? It's speculative, but.
Right, that's a good question. There's been this thought that local jurisdictions were kind of waiting to see what happened through the emergency regulations and now the permanent regulations, and really see where things land, and that might give them a level of comfort to kind of get, get into the whole regulatory structure and look at being permissive. So we've talked about that. It is speculative. I don't know, but if you are permissive, your businesses are licensed, they're regulated, they're inspected, all of those other things. Product is tested, all the things you talked about. Protecting the environment, ensuring public safety, and all those things go along with it. So hopefully, we'll see the local jurisdictions learn more and see what's happening at the state level, and they'll feel more informed.
Great. Well, we are going to go ahead and wrap it up. Please send me any more questions. We will do our best to get answers. We will be uploading all of the resources and fact sheets provided by CDFA on our resource section and tab of our website. So make sure that you're paying attention to those, staying on top of movements from the CDFA. Yeah, absolutely.
Okay,
please.
Sorry.
No worries.
One last thing came to mind, if I could, where I was making my plea to everyone to be diligent, be proactive, go in and check your application. Here's one other thing that will help with the process too, is in your application, if you have local approval and you provide us that document, whether it's a local license, permit, authorization, like you did for your temporary license, provide that to us, then that puts you in a 10-day local authorization bucket, versus if you don't do that, the local jurisdictions have 60 business days. When we notify them that you've applied, they have 60 business days to get back to us. But if you provide us proof of local authorization, then that puts it in a 10-day window, which helps accelerate the process. Once again, if you log into your account and you see that you're in the local authorization phase, contact your local permitting office and ask them if they've heard from CDFA and if they can tell you where they are in the process. Just that communication and that being proactive on your part as the applicant will really help speed things up. So
excellent.
Thanks.
Well, I would love to thank the director of Calcannabis's Cultivation Licensing, Director Richard Parrott. Thank you very much for being here. Thank you for working with the industry. And thank you for your guidance in how to streamline operations for us folks.
Okay, thank you.
So again, send your questions. We will do our best to get those answered and posted to our site. So thank you very much to the CDFA, and we will be starting in about 15-20 minutes with the California Department of Public Health. Thank you.
Thank you.
Thank you, Richard.